General Data Protection Regulation. The General Data Protection Regulation 2016/679 is a regulation in EU law on data protection and privacy in the European Union and the European Economic Area. The learning objectives for this course: what does GDPR do? Organizational perspectives, technology, data, key activities and considerations, key privacy and data protection areas. Let's start with what does GDPR do? GDPR carries provisions that require businesses to protect the personal data and privacy of EU citizens for transactions that occur within EU member states. The GDPR also regulates the exportation of personal data outside the EU. It also protects personal data and the privacy of EU citizens. And it restricts the export of personal data outside of the European Union. The GDPR introduces new requirements and challenges for legal and compliance functions. Many organizations will require a data protection officer, or DPO, who will have a key role in ensuring compliance. It's estimated that 28,000 new DPOs will be required in Europe alone. If the GDPR is not complied with, organizations will face the heaviest fines yet, up to 4% of global turnover. A renewed emphasis on organizational accountability will require proactive, robust privacy governance, requiring organizations to review how they write privacy policies to make these easier to understand. When it comes to technology, new GDPR requirements will mean changes to the ways in which technologies are designed and managed. Documented privacy risk assessments will be required to deploy major new systems and technologies. Security breaches will have to be notified to regulators within 72 hours, meaning implementation of new or enhanced incident response procedures. The concept of privacy by design has now become enshrined in law, with the privacy impact assessment expected to become commonplace across organizations over the next few years. And organizations will be expected to look more into data masking, pseudo-anonymization, and encryption. Individuals and teams tasked with information management will be challenged to provide clear oversight on data storage, journeys, and lineage. Having a better grasp of what data is collected and where it is stored will make it easier to comply with new data subject rights, rights to have data deleted and to have it ported to other organizations. Data protection officers. Organizations processing personal data on a large scale will now be required to appoint an independent, adequately qualified data protection officer. This will present a challenge for many medium to large organizations, as individuals with sought-after skills and experience are currently in short supply. Organizations will also be challenged to demonstrate an independent reporting line, which could cause issues with incumbent positions. Serious noncompliance could result in fines of up to 4% of annual global turnover, or about 20 million euros, whichever is higher. Enforcement action will extend to countries outside of the EU, where analysis on EU citizens is performed. But how will this play out in practice? Will US organizations, for example, take heed of EU data protection authorities? The current requirement to provide annual notifications of processing activities to local regulators will be replaced by significant new requirements around maintenance of audit trails and data journeys. The focus is on organizations having a more proactive, comprehensive view of their data and being able to demonstrate that they are compliant with the GDPR requirements. Clarity and education is key. Organizations will now consider carefully how they construct their public-facing privacy policies to provide more detailed information. However, it will no longer be good enough to hide behind pages of legalese. In addition, there's a significant shift in the role of consent, with organizations required to obtain freely given, specific, informed, and unambiguous consent while being able to demonstrate these criteria have been met. Branch reporting within 72 hours of detection. Significant data breaches will now have to be reported to regulators and in some circumstances also to the individuals impacted. This means organizations will have to urgently revise their incident management procedures and consider processes for regularly testing, assessing, and evaluating their end-to-end incident management processes. The GDPR formally recognizes the privacy benefits of encryption, including an exemption from notifying individuals of data breaches when data is encrypted. However, this does not mean that organizations can afford to be complacent, and the exemption may not apply when weak encryption has been used. Given the potential fines, organizations will have to further increase their focus on a robust information and cybersecurity regime. Online profiling becomes a loaded topic. Individuals will have new rights to opt out of and object to online profiling and tracking, significantly impacting direct-to-consumer businesses who rely on such techniques to better understand their customers. And this applies not just to websites, but also to other digital assets, such as mobile apps, wearable devices, and emerging technologies. The concept of privacy by design is nothing new, but now it is enshrined in the GDPR. Organizations need to build a mindset that has privacy at the forefront of the design, build, and deployment of new technologies. One manifestation of PBD is data protection impact assessments, which are now required to be undertaken for new uses of personal data where the risk to individuals is high. Data inventories. Organizations will have to take steps to demonstrate they know what data they hold, where it is stored, and who it is shared with by creating and maintaining an inventory of data processing activities. Data leads will have to work closely with privacy colleagues to ensure all necessary bases are covered. A thorough system for maintaining inventories needs to be implemented. A new right to be forgotten is further evidence of the consumer being in the driver's seat when it comes to use of their data. Depending on regulatory interpretation, organizations may need to perform wholesale reviews of processes, system architecture, and third-party data access controls. In addition, archived media may also need to be reviewed and data deleted. A new right to data portability means that individuals are entitled to request copies of their data in a readable and standardized format. The interpretation of this requirement is debatable, but taken broadly, the challenges could be numerous, amongst them achieving clarity on which data needs to be provided, extracting data efficiently, and providing data in an industry standardized form. The GDPR recognizes the concept of pseudo-anonymous data and at the same time expands the definition of personal data, placing a greater emphasis on data classification and governance. But it remains unclear if and when certain data, for example, IP addresses, will be classed as personal data and subject to requirements. So in summary, understand and interpret the GDPR requirements in MAP to process their features and controls. Consider using a GDPR baseline approach for areas where certifications do not apply. For vendors, do not imply that using your solution will directly guarantee GDPR compliance. Lawful, fair, and transparent processing, limitation of purpose, data and storage, data subject rights, personal data breaches. The organizations must maintain a personal data breach register and, based on severity, the regulator and data subject should be informed within 72 hours of identifying the breach. Privacy by design. Companies should incorporate organizational and technical mechanisms to protect personal data in the design of new systems and processes. That is, privacy and protection aspects should be ensured by default. Now let's take a quiz to test your knowledge. Which of the following is correct? The definition of personal data in the GDPR is true or false? Under the GDPR, the term manual filing system is likely to cover files structured in date order. When a breach occurs, what is the maximum time you have to report it? Data protection is guided by certain principles on how we should handle data. Which one of the following is not one of these principles? How does GDPR define personal data? What is the maximum fine for GDPR non-compliance? True or false? GDPR makes provisions for individual member states to add their own exemptions. The GDPR introduces a new data protection principle that requires organizations to what? Which parties does the GDPR concern? Thank you.